This case is regarded as a very important case in the series of high profiles between multinational pharmaceutical company and Indian general drug company. Roche pharma vs Cipla.
In February 2007, Roche along with Pfizer claimed that it has been granted a patent for erlotinib drug and marketed under the brand name Tarceva in India.
In January 2008, it was reported that Cipla is planning to launch a generic version of erlotinib.
This made Roche initiate infringement proceedings against Cipla. Roche claimed that Cipla had infringed patent in 774, also known as erlotinib hydrochloride, which is licensed to Roche.
We had been selling its drug under the brand name Erlosip since December 2007. Roche patent was invalid because erlotinib was a derivative of quinotzoline. Roche complete specification did not sufficiently unfairly describe the invention or the method by which it was to be performed. The huge difference in price between Roche's drug, 4,800 rupees, and our drug, 1,600 rupees, should be taken into account when deciding whether or not to pass interim injunction. This is a life-saving drug and the public interest issue was an important factor to be taken into account.
Erlotinib is not salt, esters, polymorphs of a known substance. ETA is a novel compound. Section 3D of the Patent Act is not applicable. And our drug is accessible to Indian territory, and it is not necessary that the drugs should be manufactured in India.
The generic drug version of erlotinib manufactured and marketed by Cipla is available at one-third price of Roche's drug Tarceva. Tarceva is not manufactured in India, it's imported. The right to access to life-saving drugs and the need for secure long-term supplies is a serious issue in India. In such case, the injury that would be caused to the general public if the generic version of the drug were not available is a strong point in favor of a refusal to grant an injunction. The decision didn't go in the favor of Roche.
We will file an appeal against the order of the single judge, or argue that a failure to protect the rights of the patent is contrary to the public interest of encouraging for the research in the pharmaceutical field.
The division bench upheld the decision but focused more on the failure of Roche to establish a prima facie case of infringement. The SLP filed by Roche against the decision was declined as well. Division bench checked and found that the patent IN 774 stated that this compound may exist in several polymorphic forms, but any and all such forms will be subsumed within its patent. Therefore, Cipla's Erlosip being a polymorphic form of erlotinib hydrochloride, it will most certainly infringe IN 774 of Roche.
The judgment finally went in favor of Roche. The guidelines applicable to many crucial aspects of a patent infringement were clearly laid down in the judgment. Cipla was made liable to render accounts concerning the manufacture and sale of Erlosip and decreed costs in favor of Roche of 500,000 rupees. The court did not, however, grant a permanent injunction on manufactured by Cipla.